A big hello to all of you. I deeply regret the problems that affect my presentation. However, I want to share this recording with all of you due to the importance of the subject matter. The title of my intervention is The Evolution of the Concept of Human Rights Influenced by the Work of the Inter-American Court of Human Rights. 1. Approach: an increasingly influential international law. The following reflections derive from my research of the Inter-American Court of Human Rights, which is why they refer primarily to the situation that is being experienced in that region of the planet. However, these reflections can also be applied to a great extent of international human rights law in general. Currently, the notion of human rights is so prestigious in the West that everything that is said about it is considered good and indisputable, to the point that it could be considered a secular religion, trailing factor on the legitimacy of states themselves, both before its citizens as well as internationality. Consequently, human rights have become a kind of natural law in permanent construction and reconstruction. This thanks to the international consensus that has given rise to the human rights treaties and above all, to the work of the monitoring bodies, courts, commissions, and committees. For these supporters, for its supporters, this multilateral origin of international law makes in itself a more legitimate, superior, and more humanitarian reality than any state law, since the latter has only an unilateral genesis. The foregoing, since it is considered to be the result of universal or regional consensus, would make it infallible, considering that this consensus could not be wrong. However, human rights have evolved remarkably to the point that it is sometimes difficult to recognize them or to predict how they will be understood in the future, as their interpretation has been monopolized by the treaty bodies. These bodies are not controlled by anyone, and citizens have not part in their work. For this reason, this evolution has become a phenomenon that is increasingly hierarchical and lacking in accountability due to the characteristics of inter-American human rights law. Consequently, these organizations are becoming censors of the world, establishing with remarkable freedom which human rights are to be protected, who complies with them, and who does not. 2. Some characteristics of inter-American human rights law and the problems generated as a result. To better understand this last phenomenon, it is essential to recall some of the characteristics of international human rights law within the inter-American system. A. Human rights treaties have an autonomous meaning, in light of which their meaning depends on the monopolistic interpretation of their treaty bodies, not on what the state have understood when signing them or later. B. They are living instruments, so they must adapt to the new circumstances through this monopolistic interpretation in order to better protect human rights. C. The interpretation is driven by the principle of progressive interpretation, or not regression, thanks to which it is increasingly protective of the right it protects, prohibiting itself from regressing towards less favorable interpretations. D. They have ductile rules of interpretation because they must be evolutionary, dynamic, holistic, systematic, progressive, finalist, etc., thus giving a lot of freedom to the interpreter. That is why new rights have emerged, either by expanding the current ones, by discovering implicit rights, or by making an exegesis contrary to the text that enshrines them. E. The protection of these rights is influenced by the pro homine or favor persona principle, which allows the judge to choose quite freely the norm to apply to resolve a human rights case, whether this national or international norm. F. Finally, that the criteria of human rights established by international law constitute only minimum standard in terms to the requirements for the protection. This is a crucial aspect to which we will return later. Consequently, the monopolistic interpretation of these treaties has indeed eclipsing them. In short, we are in presence of other treaties, because initial consensus of the state has been replaced by the free interpretation of the human rights treaty bodies. In the case of the Inter-American system, this has given rise, among other things, to the control of conventionality doctrine, created by the Inter-American Court case law, which orders national judges to impose international criteria, that is, their own case law, over its domestic laws, even if constitutional in rank. In this way, the local judge could a. declare the national standard inapplicable in favor of the international standard in case of an absolute incompatibility between the two. B. Reinterpret the local standard in light of international criteria in order to harmonize them with each other, the so-called compliant interpretation. Or C. Apply national norms, but only if it exceeds the minimum standard of international law. In addition, since the American Convention lives in the ductile and evolving interpretation of the court, it considers that this treaty is updated with each of its verdicts. For this reason, it estimates that this interpretation is binding on all states, even if they have not been part of the dispute that gave rise to the judgment. In other words, that its res interpretada would have an erga omnes effect. The same is happening with the soft law created by other human rights treaty bodies, committees and commissions. Despite not being binding, soft law is of crucial importance today because it shows how these bodies see or understand the treaties they interpret. And it is in accordance with this soft law that this censor of the word judge whether or not the states are complying with human rights, making the legitimacy depend on it. Therefore, we are faced with the existence of two parallel legal orders, the national and the international, the latter demanding complete obedience from the former. 3. The relationship between these two parallel legal orders. To better understand the foregoing, it is necessary to take into account the principle of minimum standard. Now, if we look closely, the situation is surprising. Indeed, the fact that the interpretation of human rights treaties is considered to be the minimum standard implies that the defenders take for granted that their way of understanding this right is correct and indisputable. Hence, we can speak of a kind of an infallibility complex. Consequently, this censor of the word intends to monopolize the notion of right and wrong at a global level, demanding complete obedience from national legal systems. The foregoing explains why this parallel international legal order requires that national legal systems must adapt without delay to their criteria, taken at the minimum standard, exceeding it if possible, but never contradicting it. In this way, thanks to the control of conventionality, this minimum standard emanating from the jurisprudence of the Inter-American Court always ends up winning. Always. This occurs evidently by failing to apply local regulations in favor of international ones. But the same thing happens when carrying out a compliant interpretation, since it is guided and dominated by these foregoing criteria, so that its effects can be as drastic as those do non-application. And finally, it also happens if the local standard is used, since this is possible only because this minimum standard has been adopted and exceeded. Consequently, implicitly or explicitly, the criteria of this parallel international law always end up being applied. Therefore, it is always local law that must adapt to international law, but not the other way around. Thus, a notable legal Copernican twist, a legal Copernican twist occurs between states and international laws in state as states end up being dominated by their own creation. The foregoing means that the role of the states would become increasingly supportive and secondary, limiting themselves to following or improving international criteria, placing all the resources to their disposal to make them come true. From the reason, conventional control is always intended to be applied to the executive and legislative branches, so that they do not deviate from the jurisprudence of the court when issuing the rules, laws, decrees, regulations, etc., seeking to reach a sort of legal monism. Similarly, democratic decisions would be limited by the minimum standard, generating a democracy that is tutored or protected by these international human rights. And the same could happen with constituent power. The idea is to produce a growing standardization between both normative orders for which the Inter-American Court intends to become a continental constitutional court and the American Convention on Human Rights a continental constitution. Therefore, it is intended that all states apply the res interpretata of this court with erga omnes effects, thanks to the work of their local judges and other authorities through the conventionally controlled doctrine, arriving at something similar to a global constitutionalism. 4. Toward a single thought protected by the state. The remarkable prestige that human rights still have in the West, hand in hand with the work of the monitoring bodies are met with an infallibility complex, is imposing with less and less dissimulation a single thought that is increasingly difficult to resist, since currently it is considered that no one can be so heartless and vile not to support something as human rights elevated to the category of a new natural law. That is why human rights end up imposing their way of seeing things by having a kind of priority pass, making dissidence or criticism increasingly difficult. Thus, because everything they touch becomes a dogma, what we call a talisman effect of human rights. But in addition, we must not forget that these rights are under permanent construction and reconstruction by the censors of the world, raising the bar of the minimum standard more and more, thanks to the principle of progressive interpretation or no regression. Consequently, those who do not accept this state of affairs will be considered the heretics of our time and even a danger to society. From the reason and in the name of these same human rights, they could be deprived of their own rights. In short, these human rights would end up generating an authentic thought police, ultimately dependent of these censors of the world. Finally, another aspect of great importance is the growing role of the state in the implementation of these rights, which must be of total support to making them a reality. And since these rights have become a new secular religion, we are ultimately in the presence of confessional states being forced to adopt this substantive content derived from the minimum standard on which their legitimacy depends. For the same reasons, human rights must affect all spheres of life, giving the state the perfect excuse to interfere in all areas of the existence. Therefore, far from being a kind of shield to protect against certain state interference, today the current human rights are quite the opposite. 5. Some conclusion. Perhaps the most important thing is to realize that the supporters of the process intend to give rise to two parallel legal orders, with international law as dominant and legitimizing by endowing it with infallibility and unquestionable superiority, almost a deification, regarding it as the minimum standard and trying to turn the states into its mere executing instruments. This because international law can always modify national law, but not the opposite, except to improve it. Thus arises a heteronomous conventionally control, that forces local law to permanent adaptation. Today's human rights, the secular religion of our time, seek to arrive at a single thought by transforming that they defend into dogma, the talisman effect, and prohibiting dissent. But being in permanent construction and reconstruction, they are a perfect Trojan horse to introduce the content decided by the sons of the world, and thus impose human duties on societies, being endowed with a presumption of legitimacy and considered a kind of new natural law. For the same reason, these rights allow the state to intervene and regulate everything, becoming a big brother. Consequently and paradoxically, far from being a protection for our freedoms, human rights, as we know them, are becoming a new form of totalitarianism and an instrument of domination. Hoping you are well and asking God's blessing for us, I say goodbye with affection. Thanks for your attention.